Any mention?
Wait, please, Your Lordship. Lordship, I beg to mention item number 9, Your Lordship. Item 9, Your Lordship.
9?
Yes. Lordship, Lordship, yes, Your Lordship. I have informed the bank respondent, Your Lordship. I pray, Lordship, that this matter may be come up after 3 weeks, Your Lordship.
No objection.
Where's Dr. Mojita? Objection. Where's the Mr. Security? The petition?
No, Your Lordship, yes. Nothing.
Is that post office matter?
This is the bank matter, Your Lordship.
Bank or bank matter?
Yes.
After 1 week?
3 weeks, Your Lordship.
Why?
Lordship, actually, on the last date, we need to produce some citation authorities.
For 3 weeks?
Whether 2 weeks, Your Lordship.
2 weeks, huh? Yes.
Highly obliged.
Yes.
Item number 8, my lord. It's a part-heard matter, my lord.
Yes.
Actually, Mr. Goel is appearing in this matter and he was supposed to argue the matter physically, my lord. But due to some difficulties, my lord, he could not travel to Shillong today, my lord. It may kindly be listed after 2 weeks, my lord. We have taken consent of the respondents.
Lordship, I'm for respondent 2 to 4.
Where's the respondent? Okay. Okay, yes. Yes.
Highly obliged, my lord.
Highly obliged, Lordship.
Item number 1.
Please, Your Lordship. Lordship, the matter is fixed for admission hearing today, but the private party was the petitioner in WPC. She haven't appeared. We have to file affidavit. We just received the status report.
The last order says so. Yes, MS Herman, Merit Counsel for the appellant submits that status report has been received with regard to service on respondent 7 and 9.
Lordship.
He please allowed to file service affidavit within 1 week.
Lordship.
Phrase allowed. Return unserved 8. See. We'll take fresh step on 8 then. Was this customer not refused to refuse?
She refused.
Yes. So for only 7 and 9 you file affidavit, and for yes, she prays is allowed 1 week's time to file self affidavit. Stop. Office note indicates, however, that the respondent number 8 has refused service. That's why it's deemed served. Yes, after 1 week. Yes. Apply.
Item number 2.
Yes.
Please, Your Lordship. Lordship, I'm playing for further 2 weeks' time, Your Lordship, to file my rejoinder.
What rejoinder?
Rejoinder to the affidavit that.
How many times you've asked?
This will be the second time, Your Lordship.
When was the affidavit filed?
On the 12th, Your Lordship.
12th of?
12th of February, Your Lordship.
Okay. It's further 2 weeks' time as paid allow for rejoinder. It's expected the next day the rejoinder should be on board. Or we'll fix it for hearing in the meanwhile. Right.
Let's be in orders, Your Lordship.
Okay. Yes.
Highly obliged, Your Lordship.
3.
Connected, Your Lordship. My apology, Your Lordship, is connected.
Connected matter, Lordship.
Just together with 249.
4.
May it please your lordships, on the previous, sorry.
Isn't this yes.
May it please your lordships. On the previous occasions, lordships had indicated that you were concerned about our appeal to section 260 of the Income Tax Act, which doesn't lie.
Have you served the council?
No, lordship. In fact, my prayer today is essentially for amendment of the writ petition before we file.
Put an application. That'll be considered.
Please, lordship.
Yes, Mr. ASD raised that we were allowed to put an application to amendment. But first serve the, at least serve.
We'll
I'll
serve.
withdraw it and file afresh.
Should we do that? May please, Your Lordship, if we could withdraw and file afresh, I think this one.
This submits are due to certain defects in the writ petition. We put it to withdraw the same with to file afresh. If so advises. Prayers allowed. The matter stands closed for withdrawal. However, liberty is prayed.
Grateful.
Hearing.
You have not even served. No.
Item number 5.
That's right. Yes, yes.
Lordship, please, Your Lordships. Lordships, in this matter, we're adopting the submissions of Senior Counsel Dr. Saraf, Lordship.
Yes, yes.
Learned Advocate General was supposed to appear in this
Well,
case.
Advocate General.
He's on his legs before.
Legs where?
Supreme Court, I think. Oh, courtroom number 1, I think.
We wait for him. What do? We can't wait for him. You start first. You have to make replies.
Yeah, we have to make replies.
Yes, then make your replies. This is connected, right? It's Dalmia Cement, GV Textiles.
Already adopted this submission.
6, number 6.
My lord.
Dr.
My lord, I am appealing number 6, my lord.
Yes. You can just refresh us and then yes, by the time I think AG will come.
My lord,
Yes. Yes. Yes,
my lord,
just refresh us. Yes.
my lord, I will just refresh, my lord.
Yes.
My lord, one earlier case was the judgment was rejected. This is another case.
Yeah, but then we're reserving it, thinking that we'll hear these quickly and pass judgment together. But I think that these got stuck, so the judgment also could not be passed.
No,
That is the problem.
This is, my lord, this is a matter relating to section 45 of the Meghalaya VAT Act,
Yes.
and your lordship may kindly see section 45,
Yes.
which is reproduced at page 11.
And item number 6. Number 6. The 6. Page.
Page 11, my lord, at the bottom, and it starts at page 12, starting of the petition.
Yes. One second. Yes. Yes.
Page 12 below.
Yes.
May I read only?
Assessment. Yes.
Assessment, and at page 12,
Yes.
if no returns are furnished by a registered dealer in respect of any period by the prescribed date, or if the commissioner is not satisfied that the returns furnished are correct and complete, the commissioner shall proceed in such manner as may be prescribed to assess to the best of judgment the amount of tax due from the dealer, and in making such assessment shall give the dealer a reasonable opportunity of being heard. Now, you also may kindly see the preconditions for the exercise of the powers under section 45
Give no return
are
furnished.
first that no returns are furnished. Secondly, my lord, the commissioner is not satisfied that the return furnished are correct and complete. So this is the satisfaction of the commissioner that the return furnished are not correct and complete. Then he may proceed in such manner as may be prescribed. You could also kind note below. He has to proceed in such manner as may be prescribed to assess to the best of judgment the amount of tax due from the dealer, and a reasonable opportunity of hearing has to be given.
Yes.
These are the preconditions for the exercise of the powers under section 45 of the Act.
Yes.
Now, in the case of the petitioner, my lord, the first condition is not fulfilled because the returns were furnished.
Okay.
Now, the second, that the commissioner is not
Yes,
satisfaction.
yes,
Now, in the present case, there is no satisfaction of the commissioner that the returns are not correct and complete.
yes,
I show to you, Lord Similar. Thirdly, the commissioner shall proceed in such manner as may be prescribed to assess to the best of judgment. Now, prescribed means prescribed as per the rules. That is definition of the prescribed under the Act.
yes,
And no manner has been prescribed under the rules for making the best judgment assessment as per section 45.
and give reasonable opportunity.
And fourth is, my lord, about the best judgment assessment, which means, my lord, not on the basis of the books of account, but a best judgment assessment. And fifth one is that, my lord, a reasonable opportunity of hearing has to be given before taking action under section 45 of the Act.
Yes.
Now, our contention is that, my lord, that no such opportunity of hearing was given under section 45 because no proceeding was initiated under section 45 of the Act at all.
Okay.
And the lastly, which is there, my lord, two submissions which I advanced in the earlier one case, my lord, that there is no time limit prescribed for completion exercise of the powers under section 45 of the Act, and thereby that power must be exercised within the reasonable period, and the reasonable period has to be determined on the basis of the scheme of the Act as per the judgment of the Apex Court, my lord. And the scheme of the Act, the maximum period in any case is 5 years.
Yes.
And in this case, the order has been passed for the periods from 2007 onwards in the year 2022. And thereby that is also
Beyond 5 years.
beyond 5 years, as per, although no time limit is prescribed, but the scheme of the Act, it is 5 years maximum, even for reassessment also, not 5 years. And lastly, the power has not been delegated to the Supreme Taxes. So the power which has been exercised is illegal. Now I will take your lordship to one of the order which has been passed by the Supreme Taxes, my lord. Your lordship may kindly take the trouble of looking at page number 160, my lord. And one more submission, my lord.
Yeah.
This assessment, my lord,
Yes.
160.
Yes. Yes. 160.
Now I must mention, my lord, here, these assessments have been completed under the Central Sales Tax Act 1956. Now, item number 10, section and subsection under which assessment made, section 9 of the Central Sales Tax Act, read with section 45 of the Meghalaya Verdict.
Where we reading from?
From number 1 to 10, my lord. Number
Okay.
serial number 10.
Okay. Yes. Right. Right.
In fact, it should be reversed, my lord. The power under section 45 of the Act, read with section 9, but in any case, my lord, the intention appears to be the same.
Yes.
Now, your lordship may kindly see, Sri so-and-so representative of the company appeared with the books of account which were duly verified. Your lordship may kindly note it, my lord,
Yes.
that the books of accounts were
Verified.
verified and duly verified. As the dealt in so-and-so gross turnover, I will not go into all those things, my lord. The mentions are there. Thereafter, the turnover has been determined and it has been completed.
Yes.
Now, you will also have seen section 45. Section 45, the first condition is that the
If no returns
commissioner-
are filed.
First, returns are not filed, so that is not fulfilled in the case returns were filed.
Satisfaction. Next one.
the commissioner's satisfaction that the returns are not correct and complete.
Yes. Yes.
Now, your lordship will find that nowhere
Yes.
there is a satisfaction of the commissioner that the returns are not correct and complete.
Hmm. Yes.
And the power is to make the best judgment assessment.
Yes.
The best judgment assessment, as your lordship is aware, my lord, is to the best of judgment of the assessing authority.
Yes.
When any assessment is completed on the basis of the books of accounts and documents, after
Yes.
verification of the books of accounts and documents, the same cannot be said to be a best judgment assessment.
Yes.
Now, your lordship may see
Yes.
the last line. Hence, the return submitted can be accepted as complete and correct, and the assessment is completed as under.
Yeah.
Now, if the returns have been accepted to be correct and complete, although the satisfaction has to be of the commissioner, but if the assessing authority also feels that the return submitted can be considered completed, correct and complete, then the question of exercise of the powers under Section 45 of the Act does not arise.
Yes.
Because the first precondition is that, my lord, the satisfaction that the returns are not correct and complete.
Yes.
Where the assessing authority himself is saying
The return
that the
satisfaction is
return-
complete and correct. Yes.
correct and complete. If the returns are correct and complete, well, where is the question of exercise of the powers under Section 45 of the Act?
Right.
Now, your lordship may kindly see that the respondents are relying on a notice which your lordship find at page 17 of the affidavit of position. Yes, affidavit of position. It is, sir.
This notice is dated 2017, April 2017.
So, my lord.
Yes.
Now, you also kindly see, my lord. Their contention is that this was a notice which was given, and thereby the reasonable opportunity of hearing was given.
Now
I
he
will just
appeared.
read-
One second. He appeared on which date? He appeared.
No, that date-
the date.
no,
Where's
the
the
date-
date? The date's given where he appeared. This is for
No, it is-
petitioning 2011. Date is 3/1/23. See, Manoj Verma appeared with books of account which are duly verified. And which date did he appear?
Then, my lord, you also may see at page 19A,
Of the affidavit.
affidavit, my lord.
Yes. Yes. Or
2017, then 2021, my lord.
You mean to say through a notice dated 17, they're showing that he appeared in 1910-21?
My lord, 17 he paid the taxes, then 21 he appeared.
Yes, you. This is 27,
And then-
2017. Yes.
Then 23 is also important, my lord. Returns scrutinized under Section 39 of the Meghalaya VAT Act.
Yes.
Account, this is
Anomaly.
what is
Anomaly found.
anomaly found, recorded in SR sheet, issued notice in the Section 20.
Yes.
Now, your lordship may kindly see, my lord. This note sheet, whatever is there, all the sheet, this was notice under Section 39 of the Act, which was under the Meghalaya VAT Act. which Lordship has already heard.
The return scrutiny 39.
That is scrutinized under section 39, and I argued on the basis of the earlier petition below. That was under section 39 of the Meghalaya VAT Act. Now, this is a proceeding under the Central Sales Tax Act 1956. Now, your Lordship will see the notice, my lord. I may just take your Lordship to the notice, my lord. Subject production of the books of account.
Yes.
Now, my lord, under section 45, the question of the production of the books of account does not arise, because the order has to be passed on the satisfaction that the returns are not correct and complete, and the commissioner has to pass a best judgment assessment.
Yes.
The question of the production of the books of account does not arise.
Because without production of books of account, how will he come to satisfaction or dissatisfaction? Simple as that.
My lord?
I'm saying if you don't produce books of account, how will you be satisfied or unsatisfied? That's the thing.
Well, that is on the return.
Yes.
Well, that is on the basis of return. You also
Exactly. Yes.
But not on the basis of books of accounts.
Yes.
The return is not correct and complete.
Yes.
The books of accounts are to be produced when there is an audit assessment.
Okay.
There are two things. One is the assessment, another audit assessment under the Act, where the books of accounts are to be produced and the audit assessment is to be completed.
Only one thing, Dr. Sarab, we are finding some difficulty with the, the chronology of the dates and the notices. Whether they relate to same proceeding or whether they relate to some other proceeding, especially this notice dated 17.
I will submit one thing only. This is the notice on which they are relying on.
So where's the link?
17. There is no link. I am saying there is no.
Where's the link?
No link at all.
Between the proceedings under section 45 and this notice?
Well, that's why I am saying there is no link at all. And you'll also just see in the text portion, 4 lines, if I read,
Yes.
With reference to the subject cited above, you are hereby directed to remind to produce the book office, understand the books of account noted above for the periods from May 2005 to 31/12/2016 under the Meghalaya Value Added Tax Act 2003. You'll also kindly note it, my lord.
Yes.
And so, positively failing which, the assessment of the above period will be completed to the best of judgment without further reference to you, that is so and so. Now, my lord, the assessment under the Meghalaya Value Added Tax Act and the Central Sales Tax Act are two different.
That is one.
By virtue of section 9(2) of the Central Sales Tax Act, my lord, the state authority, sales tax authority, has also been empowered to complete the assessment under the Central Sales Tax Act, and the provisions of the Meghalaya VAT Act will also be applicable for the completion of the assessment under the Central Sales Tax Act. So the state authority is acting as a delegate of the central authority, but the assessment has to be completed under the Central Sales Tax Act. Your Lordship will see the order under the assessment under section 45, which I placed before Lordship. That is under the Central Sales Tax Act. In the top, your Lordship will see.
Yes.
So, this notice cannot be said to be a notice for invocation of the powers under section 45 of the Act, because the notice can only be issued when the commissioner is satisfied that the returns are not correct and complete.
Yes.
Here in the notice you will also find, even if assuming for the argument's sake, the department's contention accept that this is the notice, then also this notice does not say that your returns are not correct and complete, and thereby I proceed to make the best judgment assessment. Kindly come and appear and explain. Without fulfillment of the first mandatory precondition,
yes,
the question of issuance of any notice for hearing does not arise.
Yes.
Because the notice for hearing is only for making the best judgment assessment. Here it says that produce the books of accounts and documents, and in case you don't produce the books of accounts and documents, the best judgment assessments will be completed, which is the audit assessment. Which you'll also find the audit assessment. Section 55, Miller, in the book. It will actually look into section 45, Miller. Oh, 55.
Right. Audit assessment, yeah.
55. Well, in the petition we reproduced at page 16.
Yes.
We will also see audit assessment. Number C. The commissioner is not satisfied with the correctness of any return filed under section 35 or content of the claim or exemption so and so. The commissioner reason to believe that a detailed scrutiny of the case is necessary. The commissioner may, notwithstanding the fact that the dealer has already been assessed under section 54, serve on such dealer in the prescribed manner a notice requiring him to appear on the date and place specified therein, which may be in business place or in place specified notice, and produce or cause to be produced the books of accounts and all evidence on which the dealer relies in support of the return, including the invoice, if any, so and so, so and so. Thereafter, you also see the dealers have produced the conducted, and thereafter you also can see 4.
Yes.
If the commissioner is prevented from 5. If a dealer had not furnished return in respect of period prescribed date, or has furnished incomplete or incorrect returns for any period, or has failed to comply with the notice under subsection 1 or subsection 3, or has failed to maintain accounts in accordance with the provisions of this act, or has not regularly employed any method of the accounts, the commissioner shall assess to the best of his judgment the amount of tax due from such dealer. So under section 55 also, the power of best judgment assessment is conferred on the commissioner, but subject to the conditions 1 to D, which is specified herein above. The commissioner can make a best judgment assessment.
Yes.
Am I clear?
Yes.
So the power to make the best judgment assessment, which is mentioned in the notice, my lord,
Yes.
that is in respect of section 55.
Yes.
The proceedings were initiated for audit assessment, and the time limit for completion of the audit assessment is 5 years.
So they've mixed up, they've tried to bring in the two provisions to enable them to.
No, my lord. When
Yes.
they found that section 55 power cannot be
Will not
exercised
work,
because
yes. Right.
it has become barred by limitation. So he passed an order under section 45
Yes.
without realizing the fact, my lord, that section 45, the conditions are altogether different, and section 55, the conditions are altogether different. He initiated the proceeding under section 55 of the Act,
Yes.
but thereafter he realized that the time limit for completion of the audit assessment has already expired. So he thought that, my lord, that if section 45 there is no time limit, so let us mention section 45 of the Act and complete it.
Yes.
Now in the statute, my lord, when two different powers have been given, section 45 and section 55, legislature, my lord, intended that these two powers have to be exercised in two different conditions. It's not so that 55 can be exercised, initiate, and 45 completed, 45 initiated, 55 can be completed. That is not the, my lord, not contemplated in the Act.
Yes.
Now, so far as the best judgment assessment procedure in the section 55 of the Act is concerned, my lord, the rules have laid down the manner but so far as the, my lord, the best judgment assessment under section 45 of the Act no manner has been laid down for the completion of the best judgment assessment. Now, as your lordship is aware, my lord, that when a thing has to be done in a prescribed manner,
Yes.
and the manner has not been prescribed, then the authority cannot pass the order at all because the manner has not been prescribed. Your lordship is aware of the judgment, my lord, of the Nazir Ahmed and all other judgment, my lord, that when an act has to be done in a particular manner, if your lordship looks into, my lord, the compilation of the judgments, my lord, along with my written submission, my lord, as you also got him, Lord.
Yeah.
You lost. See page 218. And the relevant part at page 225.
Famous judgment.
That is the famous judgment of Nazir Ahmed. As you also got him, Lord. Page 225.
Yes, yes.
Below first paragraph from the bottom below 6 or 7 lines, 10 lines below.
Yes.
The rule which applies is a different and not less well recognized rule, namely that where a power is given to do a certain thing in a certain way, the thing must be done in that way or not at all.
Yeah.
Now, one judgment more, my lord, I will place page 228. Paragraph 27 at page 239.
Yes.
Last 5 or 6 lines, my lord. It is a normal rule of construction, as you also got it.
Yes, yes.
It is a normal rule of construction that when a statute vests certain power in an authority to be exercised in a particular manner, then the said authority has to exercise it only in the manner provided in the statute itself. If that be so, since the commissioner cannot exercise the power of relaxation found in section so and so in the manner provided thereof, it cannot invoke the power under so and so to exercise the terms of so and so.
Yes.
Now, my lord, a similar issue came up before the Honorable Guwahati High Court. You will also kindly see, my lord, in the compilation, page 211. My lord, here you'll also see section 35 at page 214.
Yes. Where look?
Section 35, I will first read, my lord. No deduction of tax as prescribed in section 27 shall be made in respect of exempted category of goods as listed in Schedule 1 of the Act in case of the sale of goods where such sale is certified by the ascribed, this is rule has been quoted. Your Lordship, kindly, I am sorry, my lord. Your Lordship, kindly see, my lord. Section 27. I'm extremely sorry, my lord, for the inconvenience caused to your Lordship, my lord. At page, my lord, 212, my lord, at the bottom.
Yes.
Every person responsible for paying sale price or consideration for an amount purporting to be the full or part payment of the sale price or consideration in respect of sale or supply of goods liable to tax under the Act to the state government, company, corporation, authority, or any other board, whatever name called, financial controlled by substantially by the state government or a public company shall at the time of credit of the amount or payment to the payee, such amount in case by check, adjustment, so or in any other manner whatsoever deduct therefrom in the prescribed manner at the prescribed rate. So, my lord, it provided that the deduction can be done in the prescribed manner and the prescribed rate.
Yes.
Now we'll also see page 214.
So, in the absence of any prescribed manner, you can't resort to any other manner.
My lord, you said, Lord, in view of the discussion, I allow the petition setting aside so-and-so, what is so-and-so, with respondent to deduct tax at source payment to be made to the petitioner's bill and direct so-and-so. However, I make it clear that the authority, after prescribing the manner and the rate, shall be at liberty to deduct the tax at source.
Yes.
So the rate and the manner was not prescribed. Thereby, the court held that till the manner and the rate is prescribed, the deduction cannot be done. Now, my lord, what happened? After that, the rule making authority prescribed the rate, but the manner was not prescribed. So the matter again went to the High Court, and you'll also see page 215.
Yes.
And the relevant portion at page 217. My lord, it is well settled law. Have you lordship got it? No?
Yes.
It is well settled law that where a power is given to do certain thing in a certain way, the thing must be done in that way or not at all. In section 27B of the Assam General Sales Tax Act, the legislature has clearly indicated that the tax can be deducted source not only on the basis of the prescribed rate, but also in the manner. While making the said provision, definitely the legislature had in mind certain manners. It is also an established principle of law. The legislature do not use the expression which is unnecessary and redundant. Taking the plain meaning of section 27B of the Act, it is abundantly clear that some manner regarding the deduction of tax has to be prescribed. As this has not been done, in my opinion, no tax can be deducted at source in the present case and the circumstantial case. Accordingly, I set aside and quash the action of the respondents in deducting the so-and-so from the bills so-and-so However, I make it clear that the authority, after prescribing the manner, shall be at liberty to develop that access source.
Yes.
So my submission is that, my lord, when section 45 specifically provides that
Certain
in a manner
procedure.
prescribed, the commissioner may make the best judgment assessment,
Yes.
and no such manner has been prescribed for making the best judgment assessment, on that score itself, my lord, the order which has been passed by the assessing authority is illegal and without jurisdiction. Now, your lordship may kindly take the trouble of looking at rule 36 of the rules in the book, my lord, your lordship have to see.
Yes.
Rule 36, best judgment assessment, my lord.
Rule 36.
Lordship got it. 36, my lord. May I just read, my lord? The appropriate audit authority shall issue a notice to the dealer in Form 22, and the same will contain one or more regions mentioned in subsection 1 of section 55 for proceeding for completion of the best judgment assessment.
Yes.
So the manner of completion of the best judgment assessment under section 55
Is given rule 36.
is provided in rule 36.
Yes.
But so far as section 45,
Nothing
no
is there.
manner has been prescribed
Yes.
for making the order under section 45 of the Act. Now, my lord, the grounds for the more than 5 years limitation, that has already been submitted in the last case, and the same has been reproduced in the written submission of the present case also. So I'm not repeating on the same submissions because that has already been submitted, and I also my.
Yes, sorry, where's the Advocate General?
Secondly, my lord, the power has not been delegated.
Still,
that the same submissions I made in the earlier case, I have also included those submissions in the present petition, written submission also. Now, the ground of alternate remedy.
Yes.
Now, your lordship, as is aware, that when any action is without jurisdiction or is violative of the principles of natural justice or in excess of the jurisdiction, then the writ petition is maintainable. Now, your lordship, the latest judgment of the Supreme Court in the Godrej Sarali case, because here your lordship find page 193, my lord, I've given that one. Because there is no factual dispute at all. The question is whether the preconditions for the exercise of the powers under section 45 have been fulfilled or not. Secondly, whether the manner which has not been prescribed, without prescribing the manner, whether the power can be exercised or not. Thirdly, whether the limitation having not been prescribed, whether the power can be exercised at any time at the sweet will of the assessing authority. Next, my lord, when the power has not been delegated to the assessing authority, whether the assessing authority can proceed to pass an order, whether without the satisfaction of the commissioner, which is a precondition for the exercise of the powers under section 45 of the Act, the power under section 45 can be exercised. Whether the reasonable opportunity which has been said to be granted can be granted only after reaching of the satisfaction by the commissioner, and when that is only that when the returns are found to be not correct and complete, and when in the order the commissioner assessing authority says the returns are found to be correct and complete, that means the power under section 45 could not have been exercised at all, and in fact this power has been exercised only to overcome the limitation
prescribed by section 55.
My lord,
Overcome limitation prescribed by 55.
55, the 5 years is there.
Yes, yes.
So to overcome the limitation, it has been shown to be section 45 of the Act.
Yes.
But in my humble submission, not to speak of the limitation, the power is being exercised most arbitrarily, and thereby, in view of the judgment of the Apex Court, my lord, in Godrej Sarali at page 193,
Yes.
the writ petition is maintainable. I have also mentioned, my lord, in my written submission.
So Board of Revenue doesn't have, can't tackle its issues as per your submission.
Can settle the issues. Can. But the, you'll also just see, my lord, in the page 193.
Okay, yes, have this. Yes.
Para 8, my lord. What is it? Right.
Yes.
Para, my lord, justice
153.
at page 109,
199.
409, my lord,
Yes.
running page 200
Yes.
at the bottom, my lord.
That apart.
That apart, we may also usefully refer to the decisions of this court reported in so-and-so and so-and-so. What appears on a plain reading of the other decisions is that whether a certain item falls within the anti-tax statute raises a pure question of law, and investigating in the facts is unnecessary. The High Court could entertain a writ petition in its discretion even though the alternate remedy was not availed of. And unless exercise of discretion is shown to be unreasonable or perverse, this court would not interfere. In the later decision, this court found the issue raised in the appellant of the questioning legal inquiry determination of the High Court without putting the appellant through the will of the statute appeals in the High Court. What follows from the said decisions is that when a controversy is purely legal one and it does not involve disputed questions of fact but only questions of law, then it should be decided by the High Court instead of dismissing the writ petition on the ground of the alternate remedy being available. Now, we'll also make a similar. Now, referring to the facts of the case, we find that the appellant had claimed that before the High Court that the suo motu revisional power could not have been exercised by the revisional authority in view of the existing facts and circumstances, leading to the only conclusion that the expression orders were legally correct and that the final orders impugned in the writ petition were passed upon assuming the jurisdiction which the revisional authority did not possess. In fine, the orders impugned were passed wholly without jurisdiction, Since a jurisdictional issue was raised by the appellant in the writ petition, questioning the very competence of the revisional authority to exercise the summatory power, being a pure question of law, we are of the considered view that the plea raised in the writ petition did deserve a consideration on merits, and the appellant's writ petition ought not have been dismissed, thrown out at the threshold.
Yes.
And thereafter, my lord, the court set aside the order of the High Court and thereafter proceeded to decide on appeal on the merits.
Yes.
But the power of your lordship under Article 226 of the Constitution, as your lordship is aware, my lord, I need not remind your lordship, my lord, the power alternate remedy is only, my lord, that is not a rule, but when the alternate remedy is normally available, then the court will not interfere. But the court in the series of decisions have given the exemption that the alternate remedy shall not be barred when it is without jurisdiction, it is violative of the principles of natural justice,
Yes.
and contrary to the provisions of the statute.
Yes.
And all the decisions in Godrej thoroughly, my lord, all the, my lord, it has been mentioned. Your lordship, if your lordship just look at page 200 again.
Yes.
Page 200 of the judgment. In the second paragraph, my lord. At the end of the last century, this court in paragraph 15 of the decision in so and so, I'm sorry, my lord, page
Yes.
200.
Yes, yes.
At the end of the last century, this paragraph so and so, decision of the so and so, carved out the exceptions to the existence whereof a writ petition could be justified in entertaining writ petition. It's called, despite a party approaching the not availing the alternate remedy provided in the state they are, when the writ petition seeks enforcement of any of the fundamental rights, where it is violative of principle and justice, where the orders of the proceeding are wholly without jurisdiction, and where the act is challenged. Now, I am, my lord, challenging that the action of the authority is absolutely without jurisdiction, and thereby the writ petition is maintainable.
Okay. Yes, Doctor. Advocate General.
Yes, my lord.
Yes.
Lord, I was in the other court, so therefore I couldn't appear, my lord. Now the ground of challenge lordship has seen. Yes. The ground is that first ground which I have taken, my lord. If your lordship will kindly have my counter affidavit, because I couldn't get the argument of Mr. Dr. Saraf, my lord. What I request, my lord, kindly give me 1 day so that I can go through the arguments and then formulate my submissions, my lord. I can have it on tomorrow also, my lord. I can appear and then I can place the case, my lord.
Tomorrow the
so
bench
that,
not there.
Okay,
Have
my lord,
on Tuesday. We've heard Dr. Saraf, yes. I mean, the only thing is that anyway, you make submissions on Tuesday.
Yes, my lord.
Tuesday is 10th. 10th, fixed matter, yes. We'll conclude on that day. While it's still fresh in our minds.
Yes, my lord. I think I'll ask.
Yes. On the Pre-Advocate General for reply arguments, is the matter on 10th.
Lordships, in item
Your
number
lordship has
5, I'm
changed
praying
its
for
style, make it technical.
I'm praying for
and,
extension of interim lordship in item number 5.
Okay, we'll let him finish. Yes.
Lordship, this will mega technical will also be taken up on 10th, my lord. There is another connected item 6, my lord.
We are on item 6 now.
Yes,
6 I've argued.
Yes, finished. Yes. Next.
I will argue both the matters in my counter on 10th.
And next matter?
7.
7.
5, 6, 7.
All 3?
5, 6.
No, 7 is slightly different, my lord.
Yeah.
7 is on.
Yes.
7th is on different issue, my lord.
Dr. Saraf there.
Is he ready to argue 7?
7 because you will argue, then I have no. 7th I am ready. 7th is a small issue.
Yes. I think so.
My lord, in this case, item number 7.
Yes.
The validity of the SACE Act was under challenge before this Honorable Court in some other petition.
Yes.
Now, that validity, the act was declared to be ultra vires by the High Court.
Yes.
Now, after the act was declared to be ultra vires, the court said that a petition portion of the act amount collected
Be
shall
refunded.
be refunded back, and the balance amount shall go to a fund, state fund, in the Cancer Institute or something. Now, the court also said that this order is only in respect of the petitioners which are there, and will not apply to other cases. Now, the petitioner thereafter filed a petition before this Honorable Court challenging the validity, and the order, this petition was dismissed following the judgment passed in the earlier cases that no further petition shall be entertained. Now,
Where's the order, Dr. Sarah?
That order will also find in the petition below at page, first order which was there at page, it starts with page, I'm sorry, it starts with page 59. The first order, and para 15 at page 64.
Yes.
Accordingly, WPC number so-and-so are disposed of by holding that the state has no authority to impose cess in terms of the Impleadment Act of 2010, and by annulling the act as ultra vires the Constitution and requiring the state to refund 20% of the amount realized on such cess from the individual petitions to the such petitioners, and investing 30% of the total amount of cess realized under the bogus legislation for purpose of procuring the equipment for the cancer wing of the government general hospital in the aforesaid. Since the refund directed to be made to the petitioner appears to be more than sufficient, no additional order is directed to make a cost. In the unlikely event that the relevant affidavit of the Chief Secretary is not received by the department within the time directed, the department shall bring the matter to the notice of the court for appropriate action to taken in so-and-so. The refund to the petitioner should be made within 4 months, following which the amount will carry interest at the simple rate of so-and-so of the payment. And prior to that, the para 17, the directions contained in the order for refund are confined only to project petitioners who had challenged the act prior to it being repealed and before the GST regime came to play. Now, following this, the petition of the petitioner was dismissed.
Yes.
Now, after that, the petitioner approached the apex court. Order kota sir?
75.
My lord.
Dr. Sarah, we've not ready the matter, we'll have it together on the next date. At least we can correlate the dates. Yes.
There is some confusion on the pagination
Yes.
and all those things. But I'll make a pagination.
Now on the 10th only. One will complete these matters. Yes.
Well, this is a short matter. It can be
No,
completed.
yes, we'll complete. You just correlate the dates properly because yes, it just honestly take the time. Yes, list together. List on 10th. Yes.
I'll just make it serially, my lord. I'm
Yes.
sorry for the inconvenience caused there.
It's all right. That happens because we already argued the other matter. Yes, list on 10th. And by adding 5 interim orders will be Thank you.
Supplementary list. Item number 1, pronouncement of judgment.
It is seen as per Rule 7, though study leave cannot be granted as a matter of right and can be refused to exigencies of public service. This consideration is linked to Rule 50, which provides that study leave may be granted to a government servant with due regard to the exigencies of public service. These two rules are in conjunction and considered the court clearly requires competent authority when considering such requests to examine the totality of circumstances, such as eligibility, and as to whether the same, apart from having a direct or close connection with the sphere of duties, shall also be of definite advantage from the point of view of public interest. This is the matter taking into account entire facts as they pertain. The court leaves the fit the direct respondents to re-examine the request of the petitioner for grant of study leave in the backdrop of the rules, exigency, and especially the fact that, apart from the impugned grounds of rejection, the writ petition is eligible in all other respects. The entire exercise will complete in 4 weeks. Yes.
Any mention?
Lordship, I beg to mention item number 24 of the main list, Lordship. I am praying if this matter can be taken up after a week, Lordship.
This matter is concerning the voluntary resignation.
Gratuity matter, Lordship.
Otherwise, ready with the matter today.
Lordship. Learned Senior, Lordship, has some personal difficulty today, Lordship.
Mr. K. Paul.
Lordship. He is out of station, Lordship. That's the difficulty.
Matter was heard in part also, Your Lordship, sometime.
Is part heard?
Yes.
It was heard, Lordship. Yeah.
What to do after 1 week?
After 1 week.
Yes.
Lordship, a similar prayer for item number 27, Lordship.
Right, Your Lordship.
What's the matter about?
Lordship, this is regarding that work contract, Lordship, in Nepal, Lordship, where admitted dues, Lordship, amounting to 26 lakhs, Lordship, were supposed
But
to
I
be paid.
place that some amount is disputed, my lord. And
The other amount you take, the undisputed amount.
For the disputed amount,
You have not agreed to that.
Lordship, the
You're
petitioner
supposing instructions, correct?
Lordship,
You take the undisputed amount.
Lordship,
that is only really possible from this
Yes.
one.
And the other amount, then we can't, under certified, we can't give mandamus for release of the money.
Lordship, in that case, let it come up, Lordship, on Monday, Lordship, Monday or Tuesday.
Then come up now, why is the problem?
Learned Senior is leading, Lordship, so he has some submissions to make, Lordship.
They argued the matter last time.
It's already been argued, right?
It has been argued, Lordship.
I don't want, this court doesn't want to keep these matters,
Let it be on
half-cooked,
Tuesday, Lordship. Let it be on Tuesday, Lordship. I'm requesting, Lordship.
Yes, after 1 week.
Lordship.
May please, Lordship, I beg to mention item number 28 and 29, Lordship. 28 and 29.
And 29.
Yes, Lordship.
My lord, 28 to 33 is connected, my lord.
Prayer price short matter, Lordship. Regarding prayer price short, Lordship.
Regarding?
PDS, my lord, PDS.
Why on the adjournment? Is it ready otherwise for hearing?
My lord, yes, we all complete, my lord, pleadings.
If it's necessary.
No, my lord, report was also submitted, my lord, on the last occasion.
Then give a fixed date.
After Eid, Lordship.
After Eid?
Yes, Lordship.
After?
Eid, my lord. Because probably they are under Ramzan, my lord. Yes, my lord.
Ramadan, okay. After 3 weeks?
Yes, Lordship.
Yes.
March of Lordship.
28 to 33.
33, my lord.
Yeah.
Your place, Your Lordship. Lordship, I beg to mention item number 25, Your Lordship. I pray for 2 weeks' time, Your Lordship.
What happened to the PS? Where's Mr.
It's not yet
Makla?
settled, Your Lordship. It's not yet settled. We have sent notice, Your Lordship,
But
for
they support for
amicable.
judgment. Judgment was not passed by the trial
It's
court.
referring for amicable settlement, Your Lordship.
They were for mediation.
Amicable
settlement,
outside-
Your Lordship.
settlement.
Both the parties have appraised that they are trying to settle it out of.
Awesome.
But Earlier, you had submitted that the hearing's over, judgment reserved, it will be pronounced on so and so date. That's correct.
Now it says for amicable settlement.
Okay, take down. As the council submit that the matters undergoing settlement talk is matter of the 4 weeks.
Much obliged, Lordship.
Yes.
Supplementary list, item number 2.
What is this?
Your Lordship, the matter is regarding whether the petitioner's on admission has been cancelled by the respondent number 3 after being selected and also have been complying with the conditions given by the said school. And this petition has been filed by the mother, Your Lordship. And in
Where's the father?
I have repeated father in the paragraph number 1 wrongly.
He's not a court petitioner here.
No, the mother has been filed. So what happened, Your Lordship, that the petitioner's son has applied for the admissions for the KG class for academic session of 2026 in the said school, and also has followed the instruction given by the school, and also has paid the requirements fees, and also have finished the formality given by the school and the interview. However, and also has been completed all the admission, and on 31st 10 of 2025 their son has got selected
31st?
On 31st 10.
Where is that?
Page is on 14, Yana. And the annexure is on 33. The result having the roll number 76.
Okay, what happened?
And thereafter he has to comply with the 3 conditions, that is to fill up the form A, and also to submit the birth certificate and demand draft, and also to pay the admission of 20,000.
Yes.
And that also has been complied, Your Lordship. That is in annexure 5, page 34. And thereafter, Your Lordship, while this petitioner was waiting for the academic for the session to commence, in the meanwhile the petitioner was diagnosed with the allergic conjunctivitis, Your Lordship, and has gone for the under treatment, and that annexure is annexure 7, Your Lordship.
This is, you're filing a writ against a private school.
Private school, Your
How is
Lordship.
it maintainable?
It is maintainable, Your Lordship. Because the actions which has been done by the respondent, Your Lordship, because even though it is a private college, but has performed the public function, and especially in this case is for the education, Your Lordship, and which has violated the fundamental right of education and also the natural justice, because here, Lordship, he has been complied with the instruction, and also the admission also has been done. The result has been clear. There is no dispute that the son has not gone selected.
Nobody satisfied the other conditions. Getting admission
Yes, Your Lordship.
doesn't mean that you'll get admitted if you don't satisfy other conditions. See this one, induction program.
Yes, Your Lordship.
You came wearing school uniform.
Yes, Your
Even
Lordship.
on that day.
What happened in that induction program, Your Lordship? He failed to notice he failed to see the message which has been given by the
So you didn't go for the
respondent. But he have
induction.
attended, Your Lordship. He have attended.
Where's the factory attended? Otherwise, it's like counseling. If you don't go, you forfeit your seat.
Your
Simple as
Lordship,
that.
there is a photograph also that he has attended. It's not that he has not attended at all the program. He has
Photograph
attended.
where? Anyway, this is matter for any other bench. This is matter for any other bench.
Item number 3.
Lordship, I'm praying that this matter may come up next week, Your Lordship. Mr. Paul is unavailable today.
Lord, there is no urgency in the matter. My Lord, Your Lordship would recall. they mentioned.
Then we have to take pause. You took unlisted permission
listed.
And I told where's MS Data? Where's she? That you have to do 2 hearings before you get permission to unlist it again. No adjournment for hearings then. Other council don't take adjournments, fine. But where's MS Data? No, she's not here.
No, Your Lordship.
She's one of the permission.
Other court, Your Lordship.
Yes, after 1 week.
Highly obliged.
On the prayer of MSBF Parliament. We'll do that now. 2 hearings, then 1 unlisted. Otherwise, no more unlisted permission for your chamber.
Your Lordship.
Special consideration.
Item number 4.
Yes.
4.
The item 4, my lord.
Please, Lordship.
Matter relating to
We file
extension of
We filed the impleadment application, Lordship, in this case.
Leave application?
Impleadment application.
Who wants to impede here?
State was not a party, so the petitioners.
State was not
Okay.
The state and the law department.
Yes. MS case number 33/2026 in Revision 470. This is an application by the writ petitioner for impleadment of state respondents, namely State of Meghalaya Chief Secretary and Law Department represented by his Commissioner, by his Secretaries. The same are objected to by the respondents. The set to respond shall stand as respondents number
4 and 5.
4 and 5. Stop this case allowed registry to make the necessary additions. Copies of petition to be served on the State Council. Yes, Miss. What about the main case? When is coming up?
23rd, Lordship. Obliged.
Release item number 1.
Orders. Yes.
To 13. I'm appearing for 11 to 13, my lord.
Where's Mr. Deb? Ms. Jindal is here.
He's not here. Didn't see.
Your Lordship, he is out of station. If this matter can be fixed after 1 week.
Where's the petitioner?
Yes.
Not appears the petitioner on the prayer of. What's your name?
Inombre.
Oh, he's here.
I'm extremely sorry, Lordship.
You ready with the matter?
Lordship, please.
Who's the main respondent? Only you.
No, my lord.
Who's answering respondent? Main answering respondent is whom?
The Lokayukta, Lordship.
Main answering respondent.
Local.
1 and 2, Your Lordship.
Not asking the adjournment what to do.
Interim
After
order
1
is there,
week.
Lordship. Interim order may be extended.
Yes, due to the absence of Mr. S. Jindal for 1 and 2 and Mr. K. Paul for. Sorry, okay. 1 and 2. This is the matter of 1 week. Interim order when he shall continue.
Okay.
2.
Obliged.
3.
2 is correct.
Matters, Your Lordship. Let this matter must come after 1 week, Lordship.
What has happened today? Have you organized the records?
Yes, Lordship.
We are yet to. You have to organize the records. I mean, what happened last time, Mr. Shulai?
Lordship, they file an affidavit in a wrong writ petition, Your Lordship. Instead
Right.
of filing.
Yeah.
Corrected, no?
It's corrected.
Yes, Lordship.
264.
MSGCH Marak
Yes, Lordship.
submits that the record representation been organized in a proper manner. However, she prays that the matter be adjourned as Mr. P.D. Sama is not here today.
Says here, Lordship.
Why
Another
is
court,
it not
Lordship.
the matter?
Engaging in another court, Lordship.
technical difficulty one of the co-status is appellant and respondent.
We can overlook that.
We come for admission hearing, Your Lordship.
The list after 2 weeks also. Let's stop. Let them list matter admission hearing after 1 week. Yes.
Lordship. Three and four connected.
The matters come back from division bench.
Lordship, only on one issue, Your Lordship. Then I'll place
regard of this criminal proceedings.
No, Your Lord. Yes, Your Lordship. That part of the order has been stated, Your Lordship. They are to file their show cause to the report, Your Lordship. Their views and comments to the report that they have filed.
They have already filed.
They have already
then
filed.
Close it. Nothing remains then. Yes.
5.
Apply, Your Lordship.
Item number 5.
Wait, please, Your Lordship. Lordship, I may be permitted to reply on the next stage, Your Lordship. Let the applicant starts today, Your Lordship.
See?
Let the applicant starts today, Your Lordship. I may be permitted to apply on the next stage, Your Lordship.
We had filed, Lords, the bullet points on 19th August 2025. And they have not yet filed their bullet points. Are they, Lords, they are not interested in pursuing the
Interested in pursuing the matter?
Yeah, we will file on the next stage, Your Lordship.
See, Mr. Kriam, if there's no point keeping election petitions filed, it reflects very badly in the court. Because you know that election petitions are supposed to be more than 1 year. And what's happened here is even we have not even crossed the threshold of the election petition, just on procedure. We've been swimming around now 3 years.
I bow down, Your Lordship. Lordship, if the applicant could start today, I
Take
mean,
instructions from your petitioner what he wants to just do election petition or wait for. We suppose you succeed also by the time you get the final result, you go to Supreme Court, it'll be next elections would have come also, not the coming ones also. You decide, otherwise.
Lordship, we will reply on the next stage, Your Lordship, and it will be on whatever the applicant is submitting today, Your Lordship.
Mr. Pandey,
no, it is for filing a bullet point.
No, Your Lordship, on the.
You've forgotten everything now. Since the last time it was argued. How many times adjourn after this? 2010-12 adjourn file to have 2011 adjourn file to have the petitioner. This November, October. See, October twice. From September, 15 September. From 1st September rather. Mr. Snaitang 19/8/2025. The matter is listed for filing bullet points and there was never filed till now. What's the court to do? You take instructions. This matter has been repeatedly adjourned from the part of the petitioner. Stop though Mr. B. Kriam. Sorry. Today submits that the petitioners or the respondent may start the submissions and for replies to be given by the election petitioner on another date. It appears that the bullet points on behalf of the respondent already been filed. Stop considering the situation and the numerous adjournments that have been sought by election petitioner. Mr. S. Karim directed to obtain positive instructions as to whether the election petitioner is still desirous of pursuing its election petition. We list after 2 weeks. You take instructions otherwise.
No point, Manoj.
There's no point in carrying on. What's the point?
Carrying on with this.
And then even then if you argue we have to generate a judgment, it's just a waste judicial time. Everything is, you don't engage in a futile exercise, correct?
I bow down, Your Lordship.
Yes.
Item number 6.
Hello, Lordship.
May it please, Your Lordship.
Yes.
It's you move to PIL, my Lord. Now, in terms of Your Lordship's order, the details have been carried out. We have filed one status report also, my Lord.
Bye. So remains status quo at 6. You're muted. You're muted.
6, my lord. Sorry, my lord. Six are there, my lord, and we have received the report. But various witnesses are being examined, and these cases are at different stages, my lord. If your lordship will see page 2 of my status report. So far as East Khazi district is concerned, my lord, Deborah C. Marak, now 35 witnesses were there. 23 have.
Where's the indicated?
Page 2, my lord. If your lordship will have my status report, my lord. Page 2, and there is the report of additional PP, Lord, and in that report, if your lordship will see this the table, in table GR case number 240 of 2015, State versus Deborah Marak evidence, 35 witnesses were cited by the.
So now only 4 witnesses remain.
Yes, 4 witnesses. So there is some progress in this case.
And the GR case 6.
And in GR case number 56, the application has been moved by accused for transfer of the case to the district council court, my lord, and that is listed on 9th April. This case is now listed on 9th April. And the application is there. So the cases are being, whatever progress they are. And so far as, my lord, the cases pertaining to concerned, these matters are pending. Whereas Garu is concerned, matters are pending in the High Court, not in the matters. So there is some stay also in those cases. There's
a lot of disturbance coming from some place.
Yes, well, are instituted on the basis of Loka Yukta report, etc. On Loka Yukta report, and there are some technical issues.
Mr. Alpe General, I think there's some. Are you rubbing the something on your microphone? Yeah. Yes. Thank you. What is this? What about this page 8?
8 is these are the cases, my lord, where the challenge has been made by these persons, my lord. Only one, Sanjay Sangma is MLA. Boston C.H. Marak and Augustine Marak, they are not MLAs, etc. My lord. Twinkle Nevar Sangma, they are not. Only one case, I believe, serial number 2, my lord, is of the MLA.
But they're not public, not holding public office. Not the political appointees, but were they candidates?
It will not come under your lordship's under MPs, MLA. They are not MPs or MLA. Only one is MLA, my lord, serial number 2 at page 8.
So what's happened to this?
Now the case, they have challenged, the order of cognizance has been challenged by them, and this honorable court has stayed the proceedings in the trial court. So far as serial number 2 is concerned, others have also been stayed, but they are not MLAs and MPs, my lord.
Yes, sir.
And then
yes,
there is one more case.
One more cases?
At page 10, my lord, of
Medipathar.
Yes, Medipathar, and your lordship will have for re-examination page 10.
Yes, sir. Take down. A status report has been filed by the state respondents with regard to progress of matters. With regard to the first matters in question. So I will noted that from the last date, 6 matters are still pending consideration. 3 in East Khasi Hills, 2 West Garo Hills, 1 North Garo Hills, and 1 West Chente Hills. It's also seen that in the matters are in various stages and in the case of forget it, not write it. We will not record anything here.
Yes, sir. Yes, sir.
Yes, so this report is noted and taken on record. Just after 6 weeks. Or just after 8 weeks. For
yes, sir.
that's instructed, yes.
Seven.
Please, Lordship. Lordship, they have filed a impleadment application. There's no objection to that, Lordship.
Where's the impleadment application? Impleadment application. Even mistake. Contempt mistake number 4. In contempt number 47, 2025. It's an application for impleading the new Secretary Committee, DHEDC CPK Marak, as a party respondent. Same objected to by the General Counsel for the respondents. So and so shall stand impeded as respondent number 2.
One, Lordship.
Number 1 only.
Yes, Lordship.
Earlier was whom?
Lordship, former secretary may be strike out, Lordship.
Who won't strike out? Okay, then that's a submission impleaded in place of the earlier respondent, namely C. Sam Ricardo Armara. Yes. In this case, allowed registry to make the necessary correction. In this case, allowed steps with, and in the main case, in view of the impleadment of the new respondent, petition to take fresh steps.
Much obliged.
Item number 8.
My lord, we have filed a service report in respect to respondent number 6.
Yes, you find it? Yes. Mr. Didakar submits that. The service report on. You're appearing with, this is here for a petitioner here?
Yes, my lord.
It's not Mr. P. Ubin?
Yes, I am with P. Ubin, my lord.
Okay. The affidavit indicating service of number 6 has been filed by the petitioner counsel. This is, who is this? What's the matter about?
This is
ESC Infratech.
Additional compensation, my lord.
Okay.
Session Act, all these issues your lordship has also examined, but I will file the reply. On earlier occasion, stand of the state government was that no reply is required, but in law reply will be required, my lord, at least on law assistance will be required.
Lordship, I am appearing for respondent number 5 NHIDCL, Lordship. I'll file my reply, Lordship. I say 2 more weeks time, Lordship.
For state also we will file reply, my lord. For state also for assisting your lordship.
Yes, as such, notice complete all respondents of Advocate General on behalf of the respondents number 124 submits that it as an affidavit will be on examination. As on examination, affidavit will be necessary. It is allowed 2 weeks time to file affidavit of respondents. Ms. S. Pandey also a similar prayer on behalf of respondent number
5, Lordship.
5. According to this, the matter after 2 weeks. Affidavits for appearance of respondent number 6.
Most obliged.
9.
Where's affidavit?
It's for affidavit.
Yes, you are appearing for the MSB Sharma.
Yes, Lordship. I am for the petitioner, Lordship.
3 weeks time.
For the 3 weeks time, I've allowed for affidavit. This thereafter.
10.
Please, Your
Please, Your Lordship.
What instructions have you received?
I've not received instructions, Your Lordship. I'm praying for some time.
What's the matter about?
This is non-payment of this contract bills, my lord. And this matter has already been referred to the local adalat, but we want to express a difficulty because the petitioner has just underwent eye surgery, so and there are some health complications also.
Don't even refer to national. When looks national Lok Adalat?
14, my lord.
On 14th.
But it will be impossible for him to attend that Lok Adalat.
So what to do then?
Let it remain on
Have
board.
the representative.
No, my lord.
Yes, Mr. L. Shangwan submits that though the matter has been listed before the National Lok Adalat to be held on the 14th March 2026. He submits that the writ petitioner is undergoing medical treatment. He prays that the matter be taken out from the list and be what we have for affidavit.
Yes, Your Lordship. I'm praying for some time.
I will. The petitioner, due to medical condition, will not be able to attend the same. Accordingly, as far as the matter after 3 weeks to enable the GA to obtain necessary instructions.
Obliged, Your Lordship.
Item 11 also similar matter.
12?
11 same person?
Yes, Your Lordship.
Obliged.
May I please, Your Lordship? Notice has been received upon the sole respondent.
It's contempt.
Your Lordship, it's a transfer petition.
Served?
Yes, Lordship.
And once appearing.
I'll file my affidavit of service, Your Lordship.
Yes, official indicates that no, you don't need to. Official indicates that the sole respondent has been served. However, there's no appearance on one is her behalf or his on his behalf.
On his behalf.
All this, like only upon interest of justice, this after 2 weeks, then even his appearance.
13.
Your Lordship, we have taken step for that.
You are paying for whom?
I'm appearing for respondent number 2.
What about 3?
No, Your Lordship, I'm taking appearance on. We have respondent number 3.
And for district council, you are there. Or no, not district council. Sorry. It's all private. It's a private party. No, KHDC is a buyer for KHDC. Yes.
Report number 3.
You want to file a?
Your Lordship, in fact, this case, Your Lordship, has become infructuous since the tenant itself has vacated the rented premises. Your Lordship, we have no information. Because the prayer is for impleadment or transfer for impleadment of the tenant. Yes. That was rejected by the Sobated District Council Court, Your Lordship. Since now the tenant also has vacated the rented premises, this entire case has become infructuous.
What is a transfer petition?
Yes, with a prayer for impleadment, Your Lordship, of the.
Lordship, may I say? Lordship,
Number 3 is who are you?
We were the defendants there in the title suit, Lordship.
No, number 2, who are you? You're a company.
I'm number 3, Your Lordship.
In fact, I am the youngest sister of the deceased. Lordship, the prayer here, may I just express, Lordship?
Where's the petitioner in person?
Her mother is not well. She is in hospital. That's why.
Lordship, we don't have any objection to the transfer, Lordship, but in the prayer portion, Lordship, they are again seeking the same, seeking a liberty. Here, Lordship, may I just take Lordship to the prayer? Here, they're seeking a liberty to implead tenant as a pro forma defendant. Now, Lordship, this had already been decided. The petition was rejected.
The petitioner is not here, petition person. You don't know anything about the case. Yes, today MS S. Tongu had an appearance on behalf of respondent number 2 and Mr. Wansfeld for number 3. Stop. Hasad's present on behalf of respondent number 1. Stop. All respondents are present. However, as the patient person is absent after 1 week, yes, that will come in.
Obliged.
14.
Affidavit. It's a new matter.
It's a new matter. Well, here what happened, my lord, this person he appeared for the recruitment, my lord. There's a recruitment rally, composite recruitment rally for all paramilitary forces, my lord. Now he has been all paramilitary forces, my lord. Now he has been allotted CISF. CISF is not a party, so my instruction is if CISF is made a party, I'll give the instruction.
Yes, it is submitted by Musica that the petitioner had been selected for the Central Industrial Security Force, which however has not been implemented as a party respondent. From MS Panjom, next para please be allowed to take necessary steps. This list after 2 weeks.
15.
Government orders. Yes.
Lordship, I pray for 2 weeks' time to file my affidavit.
MS Tiangi B then AG so pray consular further 2 weeks time to file affidavit this so.
Pleasure.
16.
In this matter, my lord, I will press for the stay, my lord. Now, what they have done, the special committee, they have advertised, my lord. They have advertised the teacher post, my lord. And we are apprehending, my lord, they will put their people without a proper interview and all, my lord.
Who filed this caveat?
I'm sorry, my lord.
Where's Mr. Sheikh?
Let caveat be discussed, Lordship, because I haven't received the copy of the petition.
You received?
No, Lordship.
I was not informed, my lord, the caveat was there, my lord.
On the last date, on the last order, Lordship, we have informed that we have filed the caveat. This is listed to the Lordship. Let the caveat be discussed.
We have already taken steps, my lord, as per the instruction. We have taken steps on them, my lord. Last time the caveat was not on board, my lord, when a notice was issued.
Now you give them notice.
We have already taken steps, even though we'll give
them a notice on caveat, you give them, so we'll hear you on a term prayer.
My lord.
When? On Monday?
Next week, Lordship.
No, not next week, my lord, Monday. There is an urgency, my lord. What
Monday?
day?
Monday?
Monday.
Yes. Mr. S.E. Sheikh, or caveat Mr. S.E. Sheikh present for the caveat. Caveat number 126.
Other one also. Stay order.
Is also as top petition to supply copies of the writ petition to the learned counsel. Caveat stands their charges. Next, in the main case, as Mr. Sheikh submits that he has just received a copy, the matter will be taken up next week.
Monday.
Accordingly, this is a case on Monday.
My lord, highly.
17.
Right.
My lord, I have taken steps, my lord. Service notice, service report is waiting.
You are appearing for whom?
For respondent number
3 to 5.
4-5.
May it please your lordship, I've been instructed to accept notice on behalf of respondent number 3 in addition to 1 and 2.
It's okay, then Ms. ESD submits that he will also be appearing for number 3. You are Mr.
P. Karsimli.
On behalf of respondents number 4 and 5, Ms. P. Karsimli is under appearance today. Such notice complete all respondents. You want to file affidavit? No.
No, yeah.
No. He'll file.
I'll file, lordship, please.
My lord, here the limited issues as with regards to non-disclosure of the amount, my lord. That is the debts and securities of the.
They don't come with instructions, yes. It's a matter of 2 weeks instructions, the affidavit.
Wait for
18.
Lordship, here also I'm praying for 2 weeks' time to file my affidavits.
Wait for a 2 weeks time.
Pleasure.
19.
Yes.
May it please your lordship, I'm seeking a bit more time for obtaining instructions.
I'm here to receive instructions, Lordship.
2 weeks is
Grateful.
20.
I need some time, my lord, to file my affidavit.
No, you're not. This item, Mr. Q. Varsaji, right?
This is for Shillong Municipal, Your Lordship.
State
and Shillong. State and Shillong Municipal.
Yes. Oh, yes. You want 2 weeks time for affidavit?
Yes, my lord. I will file an affidavit.
Any urgency?
No,
There's no urgency, my lord.
Yes, Mr. SDF on behalf of number 1 are filing affidavit.
No, my lord. Number 1.
Non-appears for respondent number 1. Mr. SD on behalf of respondent number 2 prays that you will allow 2 weeks time for affidavit. We are allowed.
Page 21.
Yes.
Your Lordship, I have filed my affidavit.
Respondent
of
number
service
5, Lordship, entering appearance to the Lordship.
Yes, after indicating service form number 5 has been filed, Mr. S. Marapan appointed appearance. Was it 1 week time for affidavit?
1
Your
week,
Lordship.
at least 2 weeks.
Your Lordship, I pray that during pendency that my account may be defreezed, Your Lordship.
We take it up. Let him file affidavit.
Yes.
Lordship.
And also, Lordship, I just want to add the respondent number 3 and 4. Those are the authority from Karnataka, the cybercrime. They were there in the first round of the proceeding. They are very necessary. They are necessary party. Some clarification is required.
Yes.
3 and 4.
Yes.
Hearing.
Okay. Let's come back begin.
Hearing, Supplement 5.
Yes, this case is for?
Lordship, the miss case is for the impleadment of the acting same.
Yes.
We filed a miss case, Lordship, to that effect. Bring for impleadment.
I think Mr. Miss will have no objection.
No objection.
Yes, an application is miss case number 35/2026, interview C216. This is an application for impleadment of the present acting same. Sora's aimship. Same objected to by the constituted petitioner. The said acting aim shall stand impeded as respondent number
5.
Heard Mr. LCM application number 5. So you don't need petition. We already have copy of petition.
Yes, Lordship.
Yes, you want to file affidavit? No.
We will be relying on the affidavit of the
submits that.
But Lordship, in this matter,
in the main case, registry correction. In the main case, Mr. LCM was also appearing for the newly implemented respondent number 5.
Yes, Lordship. Lordship, what happened is that we have to seek further instructions, Lordship. Our instructions are incomplete at this point of time. Because
are you capable of doing anything? Or
exactly, Lordship. That is the instructions we have to seek.
The lacking in head powers.
Because why, Lordship? We are simply, as per our understanding now, we are simply a figurehead, Lordship. We have no real powers to do anything.
The counsel is appearing. When are you going to appoint a full service in?
Actually, Your Lordship, we have given the notification to the acting CM, and we have provided some of the function which we have to.
Let's see what function. You're aware of that?
No, Lordship, I'm not aware.
They haven't given letter to you. They were given to you.
I got a copy on last occasion.
Yes.
So, Lordship, I'll have to seek instructions with regards to this.
So, apart from relying on the audio affidavit filed by respondent number 4.
Yes, Lordship.
Since deceased.
Yes, Lordship.
He requires further instructions with regard to the exact functioning of the acting same.
Yes, Lordship.
Yes, then will this when?
Lordship, if I may also pray that in case that any additional contents may be brought to the...
No, that you're at liberty.
Yes, Lordship.
When you want it?
2 weeks, Lordship.
Because his, due to demise, he was on the verge of getting something, but after demise of the earliest aim, he's been denied. Yes,
yes, Lordship.
Yes, after 2 weeks.
2 weeks, Lordship.
Yes, the matter after 2 weeks for further orders. Yes.
Obliged.
22.
Lord, there is an order, Lordship, 27/11/2025. My friend was supposed to 27/11/2025, Lordship.
Yes.
Matter was heard on that day.
Yes.
Well, here the dispute is about calculation. If the dispute is about calculation, my lord, can a writ be issued, my lord, on the calculation? If they agree, my lord, they can file a suit, my lord.
This is not altogether a dispute about the calculation, Lordship. The matter is already settled. He was appointed on the same day.
You said you wanted up to the instruction.
Yes, I have.
What happened? What instruction?
The instruction is this, my lord. There is a calculation. We are claiming a particular calculation X. According to his claim, my lord, it is Y. So, can in the writ proceeding, my lord, that can be decided.
No, my lord, law says lordship.
If my lord may kindly come to para 6 of my affidavit.
No, where's the discrepancy? Show last time you showed.
Yes, lordship. Lordship will kindly see page 10, lordship. First the appointment, lordship.
Of the writ petition.
Yeah, husband of the writ petitioner, lordship.
Page 10.
Page 10. Page 10, lordship.
Of writ petition.
Yeah, writ petition, lordship. 10, sorry, lordship 12, lordship. No? This is 12, no? 12, lordship. My lord will see that serial number 61 Latifur Rahman, 10 number is Ranjit Kumar Kos, and 11 is Ravindra Kos. These were all appointed as place council secretary, lordship. Same date. Now lordship will find the gratuity so far as the other person is concerned, lordship. Ravindra Kos, my lord will find 22. Yes, lordship. How they calculate, lordship? Gratuity, leave salary amount, they give the basic pay of 10 months. And gratuity for 30 months, lordship. Thrice the leave salary, lordship. That is the calculation. Now, my lord will see another that Latifur Rahman. That is at page 24, lordship. 25, in fact. Because he retired on 2012, 14, lordship. That is why thrice the leave salary. 25, lordship.
Now, so 12 is salary, but he tried to hold 14. You retired in, your husband died in 2012.
My lord will kindly see next page also, lordship.
Now this 9,40,000. Okay.
Yes, lordship. Now my only 2,95,000. 2,95,000 they have sanctioned.
Where is that?
My lord, I'll show the leave salary part, lordship. Page,
which page?
First page 20, the leave salary.
Yes.
2,27,370. My gratuity ought to have been thrice the leave salary, lordship.
Yes.
My lord will see the next page 21.
294 is the
yes
gratuity. Yes.
I can show other many such orders, lordship.
My lord, may kindly come to the affidavit that I have filed, my lord. We have clarified.
One second. And then, what do you want to show?
There are some others also, lordship. Page 26 also. This is, although he was a supervisor Kanun Go, lordship. Leave salary is 2,68,000 and gratuity is thrice of the leave salary, lordship. Next page. Now again, lordship, one person, page 28. His leave salary is 2,23,590 and gratuity is thrice the amount of the leave salary, lordship.
You got only how much? You didn't get any 3 times, only 1 time. That means you had 227,37 rows.
Yes, lordship.
Now in page 22, there are 3 times. 227,37, 237.
Yes, lordship.
Then.
But in my case, it was not thrice the leave salary, lordship. They have only given 2,95,000.
They have given 6,82,000.
No, lordship.
My lord, I am clarifying this position, my lord, in para 6 of my affidavit. If I am permitted to read, my lord. Now that calculation is right or wrong, my lord. That he has to hesitate, my lord, in an appropriate forum.
No, if you're giving others 3 times,
no, that is what.
Why can't you give him?
That is what, my lord. We have stated in para 6, my lord, page 4. that the statement made in para 8 and 9 of the writ petition is incorrect, unfound and denied. The petitioner and or her deceased husband had never made any representation before JHDC authority with regard to the dispute in the gratuity amount. And moreover, the petitioner has not shown as to how her deceased husband was entitled for 6,82,000 so and so as claimed by her. In any event, it is to be mentioned that as per the sanction order, the petitioner deceased husband was paid 2,27,000 as leave salary, so and so as gratuity and so as interest. Further, it is humbly submitted that the notification for revised gratuity as per the notification dated so and so was approved prospectively on 4/9/2023. So whatever gratuity, my lord, he was supposed to get as per this notification, my lord, this has come into effect in 2023 only, my lord. And the people whom we have not given, my lord, whose gratuity is pending, and they have withdrawn the gratuity thereafter, my lord, their amount has been increased, my lord.
You didn't file representation also for this council?
My lord, this is the third.
Did you file or not?
My lord, they have personally approached lordship.
No, personally approached anything in
no, lordship. My lord, my lord will kindly clear the my lord will kindly appreciate one thing.
You know, gratuity is right, correct, but then the
this
even
person lordship, he
right
could not.
also, you have to go through correct.
He could not enjoy. He retired on 2011 lordship. He 2011. These are the contemporary.
He died when?
He died, lordship, when they have released the gratuity amount, lordship. After that, he could not enjoy. He was hospitalized. He was a cancer patient, and he died, lordship.
Well, because of
I
the
have
intervention
mentioned
of
lordship.
this honorable court, my lord, it was immediately released because he has made a statement that the petitioner was suffering from cancer.
He died.
We have done it immediately, my lord.
26/7/2023, and that too after filing the contempt, lordship.
Only thing, my lord, this will be according to my understanding, my lord. Let him file a representation. We'll consider it. Let him show us the calculation, my lord.
We'll keep it pending. You file representation.
My lord will write. My lord, so many representation I have filed, lordship.
Where? Let him show us one.
Not in this case, lordship. They have never responded, lordship.
We'll keep that pending.
Lordship.
Yes.
Lordship.
As the discrepancy in the amount due to deceased employee are in contention by both the parties. And noting that there's been no representation to show the exact discrepancy or the shortfall in the amount as alleged, Mr. S.A. Sheikh is permitted to instruct his client to put in a representation
with a proper calculation,
showing the calculation of the petitioner, and the said matter shall be disposed of within period of 4 weeks thereafter. This matter after 4 weeks.
One thing, my lord, if it can be recorded, my lord, let them go direct to the secretary, my lord. Normally, what they do, my lord, they just go to the peon and all. They get a receipt, my lord, and probably sometimes the peon doesn't put it, my lord, in proper time.
Yes, this matter shall receive the personal attention of the secretary to the GHADC. When the election?
Election is on 10th, my lord.
Of April?
April, my lord, 10th of April. Today there was a PIL.
Regarding for postponement?
No, my lord, for restraining the non-locals to participate in the election.
To restrain or to allow?
To restrain.
But then the candidates can be put up. That is, there's never been any bar in the Gargles for.
As per the rules, there is no bar. But
no bar.
Sentiment is also there, my lord.
Sentiment is there, but they should have thought about it earlier.
But what they did, the district council brought one notification saying that the death certificate is mandatory.
Death certificate?
No, not
that ST certificate.
ST certificate.
ST certificate is mandatory. At the time of filing the nomination.
My friend should understand, district council can pass any resolution, my lord. It is up to the governor to examine it and approve it. So if
you're a PIL petitioner?
No, lordship.
He will be filing it probably, my lord.
The manner in which the resolution was drafted, lordship, the notification was given effect from the date of the issuance of the notification. And
the law.
Last date file nomination?
16.
It will start from 10th, I think. 10th of March. 10th of March.
Very contentious issue.
Yes, it is a sentimental issue, my lord. And
contentious.
I being from the other side, my lord, to be very honest, my lord, yes, their emotion should be respected, my lord. because the institution has been set up for a particular group, my lord. Now, this is my understanding, my lord, but I don't know.
No, of course, no. 6th schedule is that was a thing to regulate anyway.
Yes.
But anyway, I would not express any. Just after 4 weeks.
23.
Again, that promotion matter, my lord. But again, here, Madam Bhattacharya is appearing.
He's still on leave.
Of course, he's not showing. She's not on a sanctioned leave.
He's having some grievous personal issues.
Perhaps, my lord.
Health issues, rather. He'll post it after 2 weeks.
Or my lord would consider appointing somebody else. Or
how will this court appoint?
No,
where's the
giving a direction
government?
to the.
Where's the AEG or someone?
My lord, have it after 2 weeks.
Just after 2 weeks, yes. As the council for this, as there's no government council present, it's after 2 weeks.
26.
You flagged the pages?
Yeah, yes, my lord. I have classified it, my lord. But certain documents are in Garo, my lord. So, if I can
Let's
just
see which one's on Garo.
Let's see. Like for example, my lord.
Important.
That is one I don't know, my lord, exactly. It will be necessary or not, because one my lord is written in Assamese. I am very helpless, my lord. Even Bangla, I don't know how to read, my lord. So
you don't read Bangla?
No, my lord. I was from Anthony School, so at that time, my lord, there was no such. So I need to just.
Second language, Bengali.
I don't know whether
How
this.
old is the document? This is 90.
Yes, my lord. So
what is this document?
I don't know what is the content of this, my lord.
Can you ask me? No.
That is why, my lord, I want to spend some more time with this file so that at least I can get the rough idea.
But this, see, revenue stamp. Mr. What is the translated copy?
So exactly, it is.
This is yes. Written by this deed of sale periodic patta, I divide sell my periodic patta lands from so. Total sum. This is between Muhammad Nayan Ali Mahajan.
So how this?
This is 78. It's not.
Yes.
What relevance?
I don't know whether it is relevant or not with this matter, but yes, I want to be very sure about it, my lord.
What
I was a bit taken by shock, my lord, when I have seen a Bangla writer.
No, this is not Bangla. This is
Assamese.
Bangla. But the thing is that it's already translated.
It's all, but whether it is a correct translation or not, my lord, that also, because no one has even put their signature, my lord, by saying that so and so has translated and all. So if my lord may kindly take after 2 or 3 weeks, my lord, I will try to figure it out, my lord. Many documents are there in Garo also, my lord.
Mr. SD submits the well-examined records, some documents and vernacular which queries examine or translate. This is the matter, not with things. But what are the Garo? The thing is that it's a Nokma matter, correct?
Nokma matter. That is why.
Then the most important thing is that anyway, the geographical table next.
Yes.